I'm just going to start off by repeating what I said in 2004, because it isn't any different from what I would say today. And then I will bring you up to date on the cases that are wending their way to the Supreme Court, including DeBoer versus Snyder in Michigan, where I have acted of counsel to the lawyer for the plaintiffs. So let me start going back. This was the presentation that I did almost 10 years to the date in 2004. Constitutional law develops in a line of growth. The Supreme Court's decision in one case serves as precedent for its decision in later cases, and constitutional rights can be extended in the line of growth. The court's 1954 decision in Brown versus Board of Education, striking down racial segregation in the public schools, was extended in 1967 in the Loving case, probably the most aptly named case in constitutional law, to strike down bans on interracial marriage. In 1965, in the Griswold case, the court held that the 14th Amendment's due process clause protected the right of a married couple to use contraception in their intimate relations. Well, that decision was extended to protect the right of unmarried persons to use contraception, and in the court's famous 1973 Roe v. Wade decision, it was further extended to protect the right of a woman to a safe and legal abortion. I said in 2004, I'm referring here to the case of Lawrence versus Texas, that the court recently held that the due process clause protects the right of consenting adults to engage in sexual relations in private. And so holding, the court struck down a Texas law directed against gay and lesbian persons that prohibited oral or anal sex between persons of the same sex. And the court emphasized that this prohibition denied gay and lesbian persons the ability to express themselves in intimate conduct with another person, and so to create a more enduring personal bond. The Constitution thus protects the right of same-sex persons to be intimate with each other, and the state may not punish such intimacy on the ground that it considers it to be, quote, immoral. The court earlier held, back in 1996, that the state violated the 14th Amendment's Equal Protection Clause by expressly denying gay and lesbian persons the protection of anti-discrimination laws. These precedents can and should be extended in the line of growth to hold that the Constitution protects the right of same-sex couples to marry. Marriage is a legal relationship based on commitment and intimacy, and it's a fundamental right. While traditionally it's meant a legal relationship between a man and a woman, there is no logical or even rational reason why marriage should be so limited. Same-sex couples can and do have the same kind of committed and intimate relationship as opposite-sex couples. They get up in the morning, they go to work, they take care of children if they have them, they share life's joys and problems, and unfortunately, like opposite-sex couples, they sometimes break up. Perhaps the only difference between same-sex and opposite-sex couples in committed relationships is how couples typically, and I use the word typically carefully, express their physical intimacy, and that is constitutionally protected. So the difference in how same-sex couples typically express their physical intimacy cannot justify the state's denying the same-sex couples the legal status of marriage that it provides to opposite-sex couples. Since the state cannot constitutionally say that physical intimacy between same-sex couples is immoral, it cannot constitutionally say that marriage between same-sex persons is immoral either. I end up by saying, I skip something, I end up by saying that in our constitutional system, we rely on the Supreme Court to define the meaning of the Constitution and to protect individual rights. The court's decision protecting individual rights will sometimes run counter to popular sentiment. But as the court has stated, constitutional rights are not subject to vote. They depend on the outcome of no election. The last sentence, even if the decision will not be a popular one, the court should hold that under the Constitution, same-sex persons have a right to marry. I don't say anything differently today, except that the public opinion has changed dramatically over a fairly short period of time. I think it has a lot to do with generational differences. My experience has been that opposition to equality for gay and lesbian persons is primarily generational. It's older people who don't want their own children or grandchildren to be gay or lesbian. Certainly young people who have grown up with gay and lesbian people who understand diversity are fully accepting of equality. I think that reflects the change in public opinion. But of course, that's irrelevant when it comes to constitutional doctrine. Now, let me perhaps get more interesting and talk about what is happening today. I think it's like 30 states, including Michigan, have constitutional prohibitions against same-sex marriage. They were adopted, 11 states adopted them in 2004. And even without those constitutional provisions, marriage law does not allow marriage by same-sex persons. The constitutional challenges have been along the lines that I suggested in this 2004 article. And it's sort of the lowest standard of review. There are three standards: strict scrutiny that the court uses to deal with race-based discrimination, middle-level scrutiny that it uses to deal with gender out of wedlock discrimination. And sort of the base standard is rational basis, that the state justification has to be reasonably related to a legitimate state interest. And while lawyers have argued for a higher standard of review, I took the position then, and we take it now, and the courts have decided that under the lowest standard of rational basis, the state cannot justify these prohibitions. Now let me switch to the Michigan case. This is DeBoer versus Snyder. You know, cases don't get before the federal courts or the Supreme Court just like that. They get there because people wanted to bring the case, lawyers wanted to bring them up. So let me tell you a little bit about April DeBoer and Jane Rouse. These two women have been in a committed relationship for 10 years or more now. Time goes on, probably it's 12 by now. And they had a commitment ceremony. They share everything in life. They are both nurses in inner city hospitals. And they adopted special needs children. I mean special needs on the verge of death. Michigan has a strange rule. Some states do, some other states do. They will allow a single parent to adopt, but they won't allow an unmarried couple to adopt, with the result that April and Jane, I think April's adopted 2 children, Jane has adopted 1. They raised the 3 children together, but because of this ban, they can't adopt each other's children. Now think about what it means to deny a child a second parent. One, the child looks different from other children who have 2 parents. But more importantly, there are significant legal differences, most important which which troubles Jane and April all the time. What if one parent dies or becomes incapacitated? If a couple is married, that's not a problem, because the other parent is still there. But if there's no legal relationship, the other parent has no status. We've seen some unfortunate cases where a same-sex couple, women, break up, where one of the women has gestated the child, and they've raised the child together, but if there's no adoption, then the other parent has no legal rights with respect to the child. And marriage confers those legal rights. In any event, they had two wonderful lawyers, Dana Nessel, our class of '94, and Carol Stanier, who represented these women in the state courts, trying to enable them to do a second parent adoption of each other's children. Sometime in 2012, Dana came and said, can you help us? We don't have any success in the state court. Can we bring a constitutional case in the federal court? Well, nothing is better for a constitutional law professor than a former student coming in and saying, can you help me? In fact, for any professor, you may remember, some of you people, the classic movie, 1982 movie with Paul Newman in The Verdict. You may remember Paul Newman is an alcoholic lawyer, not doing very well, but he's taking this case of a woman who was claimed of negligence against a major hospital in a major city, and he goes to his law professor for help in the case. It was a great movie. So I said, well, yeah, I've done this piece. It's 2002, and the claim here is that it denies the children equal protection, very much like the cases involving discrimination against out-of-wedlock children, which the court held unconstitutional case after case because it was denying these children legal parents because of disapproval of what their parents said. It's the same thing. I think it's a very good argument. Judge Friedman didn't. They asked me to present that, which I did, and the judge was very resistant. He says, look, you are really attacking the ban on same-sex marriage. Now, at truth, when the case was filed, that was secondary to Jane and April. They were happy to marry, but their main concern was to be able to do a second parent adoption. Well, lawyers know that if a judge tells you to do something, you do it. So they amended the complaint and challenged the ban on same-sex marriage. What are the justifications that the state gives for its ban on, I would like to call it now, marriage by same-sex persons? Well, the first one is, tradition. Marriage has always been between a man and a woman. Well, that is not a rational reason. Whether it's tradition or whatever, you can't deny people's rights simply because it has been traditional. And again, we come back that there's no reason why same-sex couples cannot marry. They're exactly the same as opposite-sex couples, except how they traditionally, I say typically, because as I point out, opposite-sex couples can be intimate in the same way too, but how they typically express their intimacy. So that doesn't become a justification. We know from Supreme Court precedents that notions of morality and prejudice do not justify discrimination against gay and lesbian people. Okay, then they come up with children. Married couples typically have children, but that has nothing to do with marriage. There's no requirement that people who want to marry signify their willingness to have children. Nor, of course, is there any test to be suitable to have children. But the state argues that children need a mommy and a daddy. and that children who are raised by opposite-sex couples do better than children who are raised by same-sex couples. They make that argument in the face of the overwhelming consensus of psychological and sociological evidence showing that there's no difference in outcomes between children raised by same-sex parents and by opposite-sex parents. The truth is that what children need are competent and caring parents. And judging by some of the stories we see by heterosexual parents, some of them aren't very good parents either. But the evidence is overwhelming. In most of the cases, the judges don't need to hear the evidence. They simply go through all the studies. But Judge Friedman wanted to put on evidence, to give the state the opportunity to try to justify it. So it ended up that our side put up all these experts with incredible credentials and all the studies that they had done. There was a time, a couple of years ago, where a conservative group recruited some professors basically to try to show that children raised by heterosexual couples had better outcomes in school and otherwise than children raised by same-sex couples. Now look at the study, that the main study that they did. It was a professor, sociology professor at the University of Texas. Here's what he compared. He compared children who grew up in stable families, heterosexual families where the couple stayed married. He compared them with children who had one parent who had a same-sex relationship at some time in his or her life. Now talk about comparing apples and oranges. And it was so bad that the chair of the department is a sociology professor at the University of Texas. And it was so bad that the day he testified, the chair of the department said, well, he can do whatever he wants, but I'm telling you, his study is neither conceptually nor methodologically sound. And of course, Judge Friedman gave no credit to any of these studies. So even if it were relevant, the fact is that there's no difference in outcome between children raised by same-sex and opposite-sex parents. Then you get an argument like, well, this is new. Who knows what it's going to bring? The answer is, what's it going to bring? I mean, to say we've dealt with marriage for thousands of years. There's no difference between having a same couple married and an opposite sex, same sex and opposite sex. They live their lives the same way. Then you get, well, this is going to discourage opposite-sex couples from marrying. Now picture that. Bill and Susie want to marry. And Bill says to Susie, sorry, we can't get married because we're straight. And since same-sex couples can marry, people will think that we're strange. I mean, these arguments become very extreme. But what they demonstrate is that there's simply no good reason why. The last case to come before the Supreme Court involves the Federal Defense of Marriage Act, signed by President Clinton, Bill Clinton, back in 1996. I'm sure he's embarrassed by it. But it said that the only marriage that the federal government would recognize is a marriage between men and women. Those of you who are married know that there are enormous federal benefits from being married. You follow joint income tax, Social Security benefits, immunity from estate tax. In the particular case, Edith Windsor and her wife were married in this, their marriage was recognized by the state of New York. The wife died, and she claimed the federal tax exemption. But under DOMA, she couldn't get it. She would have had to have paid like $363,000 in federal estate tax. And the Supreme Court, in a 5-4 decision, held that DOMA was unconstitutional, recognizing the state's power. It said, the states are supposed to regulate marriage subject to constitutional limits, and you deny federal recognition to people who are married by the law of their home state. What I think this decision did, and I use the term behaviorally, it showed to federal judges that there are 5 justices on the Supreme Court to be supportive of rights of same-sex persons. When I teach constitutional law, I don't do things like judicial behavior. I don't try to predict how justices are going to go. In fact, I never publicly predict Supreme Court decisions on the theory that the court is going to decide the case anyhow. My prediction, like anybody else, is pure speculation. Nonetheless, in a more intimate setting such as this, we'll do a little bit of speculation. You have 4 liberal justices on the court: Sotomayor, Kagan, Breyer, and Ginsburg. You know how they're going to vote. You have 4 conservatives. I mean, 3 of them are hardcore: Alito, Scalia, and Thomas. And they dissented in this case. And I mean, Scalia dissented in every case. He doesn't even try to disguise his homophobia. He doesn't even try to disguise it. Kennedy is considered the swing justice on many issues. Kennedy has written all the opinions for the court in these 3 cases, striking down discrimination against gay and lesbian people in very, very strong language, talking about how it harms children to deny recognition to their parents' marriage. And it's just almost impossible to believe that Kennedy would turn around and uphold the ban on same-sex marriage. Chief Justice Roberts is very concerned, I think, about the image of the court. I mean, he's the one that gave the deciding vote to uphold the Affordable Care Act, which Kennedy, popularly known as Obamacare, which Kennedy was not willing to do. I don't know how he's going to vote. It doesn't really matter. But I think that once federal judges were convinced that Kennedy is going to support striking down a ban on same-sex marriage, all the district judges that have had the cases, including Judge Friedman here, ruled that the ban is unconstitutional. The next level is the Federal Court of Appeals. And the Federal Court of Appeals for the 10th Circuit, that covers Utah, and I guess Montana was, but Utah was the main one there. For the 4th Circuit, that case came from Virginia, and recently from the 7th Circuit, coming from Wisconsin and Indiana, have all struck down the laws. Now, it's interesting. The 7th Circuit decision was written by Richard Posner, who was a very prominent conservative but libertarian theorist, a highly respected federal judge. He's not going to go in any conventional way. There were dissent, and the other 2 judges had been appointed by Democratic presidents. In the 10th Circuit and the 4th Circuit, you had 2 judges appointed by Democratic presidents saying that the ban is unconstitutional, and a judge appointed by a Republican president just saying states can do what they want on marriage, the ban is constitutional. Those are 2 to 1. All these decisions have been stayed. Our case, Carol argued it before the 6th Circuit in August, drew a panel of 2 judges appointed by Republican presidents and 1 appointed by a Democratic president. Our internal view is that one of the judges teaches at one of the Tartan, Ohio State. He's at Vanderbilt as an adjunct, very concerned about his stature. He knows that if he rules in favor of the state, he will be skewered by all the academics. On the other hand, if he's young, he's in his 50s, might hope to get on the Supreme Court in a Jeb Bush or Rand Paul presidency. But if he rules against this, he'll have real trouble getting confirmed by the Senate. Now, what's the Supreme Court going to do? We will have the first indication in 2 weeks. The court convenes in the first Monday in October. The cases from the 7th Circuit, I think all 3, the 10th, the 4th, and the 7th, are before the court. Now, the court never has to grant review in a case. Justice Ginsburg just yesterday, suggested that the court might wait until you have a decision from the 6th Circuit, perhaps, but she knows the panel just as we do, upholding a ban on same-sex marriage, in which case you have a split among the circuits, which is standard basis for granting review. On the other hand, another basis for granting review is the question is an important one that has not yet been decided by the Supreme Court. Anyhow, we will have, if the court grants review this term in a case, and I think it will, there will be a decision toward the end of June 2015. In any event, this brings you up to date. As I say, I don't want to be immodest, but I am. That basically the position that I took 10 years ago, that the state has no legitimate reason for prohibiting same-sex marriage, is what the courts are saying today. That the arguments that the state advances are really specious. They're not realistic. They don't bear any relationship to the realities of the world in which we live. And while we as civil rights lawyers and liberties lawyers expect the court to go against public opinion, as the court did when it decided Roe v. Wade. I was at the University of Kentucky during that time. I did a lot of litigation for the Kentucky ACLU, including the challenge to Michigan's ban on abortion, what I call the Kentucky version of Roe v. Wade. I wasn't very effective. The cases were heard by 3 federal judges. Nobody voted for me. But the Supreme Court decision in Roe v. Wade was truly a surprise. Most of us were arguing that the abortion laws that existed at the time that prohibited an abortion except to preserve the life of the mother were too extreme. Instead, the court basically comes up with a decision protecting women's right to a safe and legal abortion until the stage of viability has been reached, which means virtually not at all. So that was a surprise. In any event, this is where we are, and I thought that I've talked enough and that you must have some questions.
One very minor, then I'll answer your question. The minor one is the state had tried to come up with the argument that children raised by same-sex parents do as well as heterosexual parents.
Right.
But the state, if I understood you, recognizes the right of an individual to adopt a child, which means it recognizes the right of one person alone to raise a
Right.
child. And has there ever been any argument that that shouldn't be the case because of evidence that they don't do as good a job as?
Well, that's absolutely correct. I mean, that's completely irrational. And this has been pounded in the beginning. If you allow a single person to do it, wouldn't 2 parents do better? One of the things that our experts testify to is, and this is quite well, that children do better with 2 parents. That is very difficult to accept these days. because over 70% of African American children are born to single mothers. And 40% of all children are born to single mothers. I mean, the world has changed. And I've been told by my colleagues who teach family law that within that field, there has not been a lot of writing about the difference between two parents and one parent. But clearly, two parents have two incomes. And one of the things that Judge Friedman pointed out, if the state were really going to look to outcomes, it wouldn't allow poor people to marry, because children raised in lower income families do not do as well as children raised in middle class families. So this is doubly irrational. It's just another irrational example. Again, this is what we started out with, but Judge Friedman wanted to deal with the question of the ban on same-sex marriage.
Now, the bigger question, at least I thought it was, maybe it'll turn out to be the smaller one, is why can't the same argument used to support same-sex marriage be used to prevent the state from laws against prostitution or smoking marijuana?
Oh, I use the philosophy people use PIP, polygamy, incest, and bestiality. But the answer to all of this is that the state has to have a valid reason. Let's take marijuana. It is a well-settled principle that the state can protect people from themselves. It can protect you constitutionally. It can protect people from doing things that are harmful to themselves, such as riding a motorcycle without a helmet, such as smoking marijuana. The state can conclude it is harmful. They can require prescriptions for drugs. So the state has a host of regulations. So that makes it constitutional for the state to prohibit marijuana.
But on the case of marijuana, that's factually incorrect. I mean, 440,000 people a year die from cigarette smoking, and
the state could prohibit cigarette smoking. It just
doesn't. They could, but if they don't, how can they prohibit it?
It doesn't. We have the notion of a constitutional thing. State can deal with one evil at a time. Doesn't have to deal with all of them.
Okay. What about prostitution?
There are a lot of harms connected with prostitution. Rampant disease, harm to women, harm to marriage, all those things. The state, by the way, could prohibit adultery because adultery is considered harmful to marriage. There's a lot of empirical evidence to support that. When it comes to polygamy, again, marriage has always been between a man and a woman, but what's the justification for prohibiting polygamy? I have two, which makes it reasonable. The whole experience with polygamy is that it has resulted in harm to women. Dominant males with women in the relationship, it's harmful to women. Secondly, at least hypothetically, as I tell my students, if you allowed polygamy, women would be attracted to powerful men like law professors, and there wouldn't be enough women to go around for other men. So the state has a legitimate reason for prohibiting polygamy. Adult incest is really harder to justify, but I do point out that for those of us who have a male child and a female child, we'll be happy if they get along with each other. We don't expect them to have sex with each other. But what is the justification for prohibiting adult incest? Again, you only need a rational basis, and the state could reasonably conclude that that would create harm, conflict within families. Finally, prohibiting sex with animals. So you can't use you can't use morality anymore. There was a movie, Woody Allen movie. Some of us old folks remember, it's 1972. Everything you wanted to know about sex, but were afraid to ask. And Gene Wilder is having sex with a sheep. At least it was believed at the time that the sexual organs of a female sheep are similar to those of a woman. So what would be the justification for banning sex with animals? Probably form of animal cruelty or possibly spreading the disease. The point is that, one, there are rational reasons to do that. And the people who throw up these examples do not want to say it's unconstitutional to prohibit marijuana or prostitution or whatever. They are using this as a wedge to try to justify a ban on same-sex marriage, and it doesn't fly.
Oh, I guess I had 2 points. In response to the latter one, rational basis review is starting to sound kind of wishy-washy. And it's sort of
It is
sounding...
not toothless.
Well, it's toothless when you want it to
When
be
you want it,
toothless.
correct.
And then it has teeth when you want it to stop something. So rational basis review used to mean kind of almost anything that the legislator could have thought. And usually that often meant, centuries of tradition might be a rational basis. So the first thing I just wanted to say is I'm a whole lot more comfortable with some form of heightened scrutiny than using rational basis in this way. The second point I just wanted to make was, I understand why you acceded to Judge Friedman's request to make this not a case about prohibition on adoption, but rather prohibition on same-sex marriage. But I wonder if there's a danger in doing so. So up the appellate chain, the way I might look at it from the bench is to say, I'm not going to strike down a state's law banning same-sex marriage unless it's squarely presented and I have to do so. If I gave you an alternative form of relief, striking down the adoption ban, then that's enough for this case.
That thought has occurred to me, that the problem, though, let's use my favorite, this is Judge Sutton. Judge Sutton is a very able judge, Republican appointee. He's going to control the decision because the other judge will go along with him. Could that be a cop-out? I thought about that. Probably not, because Judge Friedman already said the ban on same-sex marriage is unconstitutional. Now, one of the harms of the ban is that it does prevent the second-parent adoption. But see, I see it as a fail-safe in what I believe is the highly unlikely event that the Supreme Court would hold that the state can prohibit same-sex marriage. We still have our claim that the ban on same-sex second-parent adoption is unconstitutional. As to your first point, in all the cases, the lawyers have argued for heightened scrutiny. And in all the cases, the courts have said, we don't need to deal with heightened scrutiny because the ban is unconstitutional under rational basis. When I teach rational basis, I say it makes a difference whether you're dealing with economic regulation, a company saying, you didn't regulate them, so you can't regulate me. There, the court is completely deferential. But it is it gives a little bit more scrutiny when the matter affects individual rights. Interestingly enough, the early cases dealing with gender discrimination were decided on the rational basis. Because I wrote about this even before they were decided, making the point that if the court says that the state cannot use stereotypical assumptions about men and women to justify gender-based classifications, then most gender-based classifications, which are based on stereotyped assumptions, are irrational, such as that where a couple is married and they're both working, that the husband is the principal breadwinner. That was true 40 years ago for the great majority of married couples, and it's equally true today. But the government can't say that a woman gets Social Security automatically if her husband dies, but if the wife dies first, the husband only gets it if he can prove that she earned more than he does. That may be objectively reasonable, but it's inconsistent with the value of gender equality. So I don't think it's likely that you're going to get any, so far no court has said heightened scrutiny. I don't think the Supreme Court's going to say heightened scrutiny. It has not done so in any of the three cases where it has held unconstitutional discrimination against gay and lesbian persons. So I don't see any reason why it's going to do it here. Go ahead.
Hard to know where to start with this, but it's interesting, first of all, that the question of marriage is bundled together with the material sort of benefits and
Yes.
burdens. And so if these could be unbundled, the case would look different. And the problem is now, the peculiarity of now what happens with federal law is that you can't really unbundle them because federal benefits are now going to track state law on the question of marriage as such. And so it's necessarily going to be a material difference for people if marriage laws are one way or the other, as distinct from civil unions, which are not benefited by federal law.
The matter of marriage versus civil union as a matter of state law came up in California because California did allow civil unions with all the benefits of marriage, legal benefits. And so it depended on status. And the court ruled that, because the district court, that the discrimination as to status violates equal protection.
Well, and that I think is bad jurisprudence, even though it's good political morality. And part of the reason why I think it's bad jurisprudence is because you've talked about how a moral objection to something can't ground
Right.
a prohibition. The court has so indicated, but I think somewhat improvidently. But the real problem is that here the state is being called upon to grant a moral imprimatur affirmatively, which is very different from a prohibition. And the problem, the real difficulty here, and what I think is not only rationally related to a legitimate interest, but substantially related to an important interest, is that there is an interest in authenticity in this regard, that the state is conveying through its laws what is authentically a consciousness on the part of the political community that this kind of relationship is eligible for the same kind of moral imprimatur as centuries of tradition have conferred upon marriage between a man and a woman. And the question of whether that ought to be is a very different question. The question of political morality, of whether one should vote for same-sex marriage, whether one should campaign for same-sex marriage, it's a very different question from whether unelected judges can make the determination in place of the political community.
We've been over the unelected judges. Constitutional rights may not be submitted to a vote.
Begs the question.
They depend on the outcome of no election. The state has tried to argue in these cases that people have the right to define marriage, to which the answer is, but they have done so in a way that hurts people. Now, leave out the federal benefits. Let's take your point on a simple denial of status. Since both of my children are married, I can refer to my daughter-in-law and to my son-in-law. My grandchildren can refer to their parents. Suppose that where they live in Illinois and California, there was civil union only. What do I call my daughter-in-law and my son-in-law? The partner. What would my grandchildren be calling their parents? That's the kind of tangible harm. And so I don't think it makes any difference whether the state allows civil union. There are, if you will, intangible benefits of being married. And of course there are the tangible leave out the federal side, because you can argue that that's not relevant where the state is. In any event, that's the answer that I give to it, that the distinction creates harm, it's disadvantageous to same-sex couples to be denied the status of marriage. I mean, everybody wants to be married. We really believe in marriage. That's how these amendments got passed. Heavily voted for by people who kept second marriage, third marriage, trying to get it right. But we have this aura about marriage. So if you have that aura about marriage, denying same-sex couples the ability to marry causes significant harm to them. And that's what equal protection analysis is all about. Brett, your point is a very theoretical one. And
I'm a theorist.
as Holmes has said many years ago, the life of the law has not been logic but experience. And if we look at experience, a ban on same-sex marriage is indeed harmful to same-sex couples and their children, even if the state recognizes civil unions. I, by the way, have got to leave here because the State Bar of Michigan, at its annual meeting, is giving an award as Champion of Justice Award to the members of the DeBoer legal team. Now that tells you how far we have come. One could not have pictured this a decade ago. The world has changed very dramatically.
I just had one comment, and I'm not sure I understood the previous person's comment, but it seems to be that the court granted the adoption principle without the marriage part.
Right.
Then any two unrelated people who agreed could adopt.
Okay, I dealt with that, and I think that troubled the judge a lot. The answer is that the courts have to approve an adoption. That every adoptive parent has to be approved by the court. Let me give an example. The parents are tragically killed in an accident. And there is the mother left two sisters. They want to adopt jointly. Now they're prohibited from doing so because they're not married. And yet I don't think you would object to an order allowing the two sisters to adopt. So ARPA, we went over this with Judge Friedman, he wasn't buying it. But the answer is that every adoption has to be approved as being in the best interest of children. So that presents a bizarre type of adoption, which you don't see in practice anyhow. Well, I think I need to go home. The meeting is in Grand Rapids, so my wife and I are going. And watch for further developments.
Well, here, you have a